Okay, last week the Supreme Court entered their decision in the Perez versus Sturgis Public Schools case. What does it mean? And I will tell you, breaking it all down right here, it was a very simple case. And I know that there's a lot all over social media celebrating the decision. I, my too, and my firm, we're celebrating that decision, but we're celebrating it from the standpoint that it severed a lot of the obstacles that public schools have been using over the years that have been an obstacle for other areas or other legal theories within disability rights law, the Americans with Disabilities Act, 504, things of that nature that have been obstacles to full access to consideration for relief and remedies. All right, so the Perez decision got some nuances in there. Is there a difference between relief and remedy? According to the IDEA, and I agree with this, we use it interchangeably. Court pointed that out. But what it did basically was take the Sturgis Public Schools viewpoint, which has been primarily the same viewpoint of other public schools when it's attempting to defend cases like the Perez case, meaning I believe I have an Americans with Disabilities Act violation that would entitle me for some remedy or some relief, which is, the same. To break that down, remedy and a relief is basically what you win at the end of a court case, okay? So those terms are interchangeable with regards to IDEA. That's how we've always used them. But in regard to how the schools look at it, they look at it, or they've been trying to look at it differently, and they've been able to be successful. Because the Perez case, they lost at the federal district court level, and they lost at the appellate level. Well, those attorneys pushed it further, which I'm glad that they did, and the Supreme Court rendered that decision that the IDEA has limitations with regards to what you're permitted to receive, okay? It's corrective action. So corrective action, reimbursement, things of that nature is available under the Individuals with Disabilities Education Act, not money damages. And that's where the Perez family was like, look, we got corrective action with regards to the IDEA. But the damage that had been done to their son over the course of so many years, they felt impacted him for the rest of his life, similar to, let's say, a traffic accident that would diminish his earning over time or impact him severely to where the only corrective action that would be available in situations like that would be money compensation. Now, people sit there and say, oh, the doors are open. Be cautious, because we don't know. It's been sent back to the lower courts to now consider the Americans with Disabilities Act case. All right. Now, we also know from the Supreme Court that they closed the door on 504 money damages. I think it was last year or the year before, because of a stupid case out of Connecticut. And because of some stupid cases, it ended up creating bad law in that regard, whereas it took away what used to be an opportunity for us in our disability rights field to be able to pursue, let's say, money damages along the lines of special education using 504 and Section 1983. That door was closed by the same Supreme Court guys. So I am optimistic, and I'm glad that this was done, because there's always been that exhaustion requirement. And then, of course, the sort of the devil's ointment, so to speak, that if you were to take the corrective action that is available under IDEA, well, you took the corrective action. So therefore, relief and remedy. But this is the thing. There's always going to be some relief and remedy that just simply isn't available in all situations. And in this situation, that's what the Perez family believes that they have. They believe that they have a strong enough case when it comes to proving the money damages and long-term damage done by the Sturgis Public Schools for their failure to provide on the base level, what the student needed in order to put them in a position to be able to, not necessarily maximize their potential, but I'm talking about base level. All right. That has not been decided yet. So I know a lot of people are like, oh, the door's open. I'm cautiously optimistic about that because I do believe that public schools need to be held accountable for what they're not doing. Okay, they can do more. I just think that we are spending way too much money on administrative departments, and we're not spending money on teachers. We're not spending money on the proper training and the additional resources that our teachers require in order to provide our children with that free, appropriate public education. Okay, that's what we're fighting for. We're fighting for teachers and their resources just as much as the clients we represent. Okay, they both go together. We cannot have a successful settlement agreement under IDEA unless we support our teachers and push in the services and the professional help that they require. But at the same time, have I had cases to where I believe that the dereliction and the issues have been so egregious and so constant over the course of multiple years that I feel horrible for these families, that I'm limited within the confines of the IDEA? Absolutely. Could this open the door for more corrective action? Absolutely it could. We just don't know yet. We just don't know. But being able to open the door and separate to where we could have an IDEA corrective action here in the short term, using the 2-year statute of limitations to set some things right, and then have another case under the Americans with Disabilities Act, for example, depending on how the outcome of the Perez case goes on that, it could open the door for greater relief and remedy to families that have been historically damaged, which in part was the entire purpose of the IDEA, is to correct that historical damage. But some of our schools just aren't getting it, guys, and they're not providing even a base level of the kind of services and supports that the IDEA envisions.